On the 8th of January 2024, the trial of Ousmane Sonko, former Interior Minister of the Gambia, accused of crimes against humanity, will open before the Swiss Federal Criminal Tribunal in Bellinzona. My name is Philippe Currat, and I am Ousmane Sonko Defense Counsel. Let me talk about the conditions of detention of Ousmane Sonko. Ousmane Sonko has been in pretrial detention in Switzerland since the 26th of January 2017, that means for almost 7 years. Until September 2018, he was held in solitary confinement in the prison of Biel in Switzerland. He was then held in Burgdorf regional prisons, where access to food was restricted at weekends due to the lack of staff to feed the prisoners. For more than 5 years now, he has been challenging the legality of his conditions of detention without any authority, federal or cantonal, agreeing to look into the matter. Ousmane Sonko stresses once again that the conditions of detention to which he was subjected in Switzerland constitute a violation of, inter alia, Article 7 of the International Covenant on Civil and Political Rights, Article 1 and 12 of the UN Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment of the 10th of December 1984, the United Nations Standard Minimum Rules for the Treatment of Prisoners, the UN Body of Principles for the Protection of All Persons under any form of detention or imprisonment, the UN Basic Principles for the Treatment of Prisoners, Article 3 and 13 of the European Convention on Human Rights, the European Prison Rules, as well as Article 7, 10, 29A and 30, paragraph 1st of the Swiss Federal Constitution. According to United Nations standards, solitary confinement occurs when a person is locked up alone in a cell for more than 22 hours a day. This form of detention causes serious and lasting damage to the health of detainees after 8 days in solitary confinement and constitutes a form of cruel, degrading, or inhuman treatment after 14 days. Ousmane Sonko was locked up alone in a cell 23 hours a day and was subjected to this form of detention in Switzerland for 586 days, that is 1 year, 7 months, and 9 days. To make matters worse, his cell was fitted with a window whose glass has been obscured so that he could not see the light of day or see outside. During this period, he was denied access to showers, food, and a walk in the open air during the 60 or so days of hearings conducted as part of the proceedings. On the 10th of February 2020, the Office of the Federal Prosecutor in Switzerland conducted a hearing to which Ousmane Sonko was subjected, even though he had been completely deprived of food for the preceding 30 hours. He challenged the legality of this investigative act, but the Office of the Attorney General of Switzerland refused to issue a ruling, and the matter remains contentious. Throughout the period, he also had no access to proper health care. The damage to his health is still having an impact today and is not being properly addressed. In general, the Swiss Federal Tribunal has ruled that it is up to the Tribunal of Coercive Measures, that is, the judge responsible for reviewing the legality of pretrial detention, to establish that the conditions of detention are unlawful, and then for the court hearing the case to draw the appropriate conclusions, either by reducing the sentence or by compensating the person concerned. In this case, the Tribunal of Coercive Measures declared itself incompetent, which the Federal Tribunal confirmed, referring Ousmane Sonko to the cantonal authorities. When he referred the matter to the cantonal authorities, they declared themselves incompetent, believing that it was up to the Tribunal of Coercive Measures to decide. For the past 5 years, no authority has agreed to investigate Ousmane Sonko's allegation that his conditions of detention are unlawful, and none has recognized its jurisdiction, all referring the matter to the other. The case is now in the hands of the Supreme Court of the Canton of Bern, which he hopes will finally deal with the matter.